on the three inherent powers, I believe there are still important matters that I have to discuss with you, because most of the problems that emerge in the local government units actually come from the three inherent powers, because this is an exercise of the powers of the state against the private individual, and usually these are the cause of the trouble. Okay, so but before we go into that, um, we'll discuss first a, an equal important matters now on the sources of revenue, because in the order of the documents here, okay, we have to start. We go first by the order, which is on the sources of funds, and then we go into the inherent powers, I think, which is on the later part. Now there are sources of the LGU funds which actually come out in our exam. Okay, one of that is the taxes, fees, charges, which accrue exclusively for the use and disposition. And we have the second one, the just share in the national taxes, which shall be automatically and directly released to them. And the last is the equitable share of the proceeds from the utilization and development of the national wealth and resources within their territorial jurisdiction. This refers to the development of natural resources, as for example, common is the quarry. Automatic, a certain percentage of that will go to the LGU. Now, the first one is on taxes and fees and charges, which are actually an initiative of the government how to look for funds. While the other one, the second, is the just share of the national, which is automatically released to them, and it cannot be hindered by any court proceedings. So the upon the time, or when it reaches a certain period, it should automatically be released. It cannot be um, filed by any court for an injunction. So it is automatically released. The reason is that there are services that must be performed by the LGU, such that any hindrance or any prevention from its implementation is not allowed. Now, what is an internal revenue allotment? Okay, under the Section 6 of the 1987 Constitution, the local government unit shall have the just share as determined by law in the national taxes and shall automatically be released to them. So the second part actually refers to the internal revenue allotment. Okay, and there are three sources in general. Okay, one is the taxes, one is the second is the just share, and the third is the equitable share from the national development, which are found in the territorial jurisdiction of a certain local government unit. Now, the general rule is that the LGU shall have 40% of the national internal revenue taxes based on the collection of the third fiscal preceding the current fiscal year. So the basis of that 40% comes from the third year prior to the present year. So meaning you have to count 3 years backward, and that's the basis of the 40% of the national internal revenue taxes, or the IRA. What is the exception? When the national government incurs unmanageable public sector deficit, then that 40% will be reduced only to 30%. I think I discussed this one. These are exceptional cases where the 40% will be reduced into 30%. Of course, there are requisites, one of which is that there must be an unmanageable public sector deficit, and then recommendation from the Secretary of Finance, internal and local government, and then we have the budget management. Okay, and then we have is the consultation with the heads of both House of Congress and the President of the Liga ng of the Liga. It could be the Liga ng mga League of Cities, Now, so what is an automatic release? The share of each local government unit shall be released without need of further action. Okay, as I said, the reason is so that the local government unit can address the problems immediately, okay, without waiting for a fund from the national government. So respectively to the treasurer quarterly within 5 days after the end of each quarter. So there's no holding back, okay? Not even the national government can prevent it from giving it to their respective treasurer. So the section 4, there was an executive order, okay, where they withhold the 10% of the LGU's IRA, okay, because they said there is an evaluation of a certain LGU. So until such time that the LGU will produce that document, that's the time that they're going to give that 10%. That administrative order was declared to be unconstitutional because it violates the provision that the fund for the LGU will automatically be released. Okay, so that's the important. No one can prevent it from releasing, okay, because it is provided for by the Constitution. Again, we go by the principle that this the law passed by Congress or even administrative order is just lower to the source of the law, which is the Constitution. Okay, so the stream cannot go beyond the source. Now we go into the duty of the national government agencies, okay, in the maintenance of the ecological balance. So it shall be the duty of every national agency, even the government-owned or controlled corporation authorizing, involved in the planning and implementing of any project and programs. Okay, so what are those that can cause pollution, climate change, depletion of non-renewable sources, loss of cropland? Okay, what does it mean? That they have to require, okay, an approval from the LGU. So the national government cannot just simply make a project without consultation from the LGU if it cause pollution, climate change, depletion of non-renewable resources, loss of cropland, rangeland, or anything that will affect the local government units. So basically, it's on environment. So if the project affects environment, then the project must the national government must consult the local government units concerned. Under the local government code, prior consultations is required. Okay, so no project or program shall be implemented by government authorities unless consultation is required, okay, and accompanied with or prior to approval of the Sangguniang concerned obtained. So but that refers only to, okay, anything that would affect the environment. Now, how about in the implementation of the local government units, wherein it exercises those inherent powers? Of course, there are requirements. Okay, one of which, as I discussed, an ordinance. Okay, no local chief executive can go or can enter into a contract without approval or authority given by the local sanggunian. Section 27 of the code should be read in the conjunction with 26 hereof. Thus, the project and programs mentioned in 27 should be interpreted to mean projects and programs whose effects are among those enumerated in section 27 and 26, which as I said, refers to program that affects the environment. Okay, so there are how many? There are 6. Okay, cause pollution, bring about climate change, cause depletion, eradicate certain animal or plant species. Okay, so another example is the BB talong, okay, a GMO which alters the growth of a certain corn or of certain eggplant, which is bigger compared to a normal size, but the effect is not yet ascertained. Into the effect to environment is not ascertained, so it was declared even by Supreme Court as unconstitutional, unless sometime later on the scientists can prove that indeed the effect cannot harm the environment. Now, so we go into the interpretation in favor of the local autonomy. Now, in many instances where when there is a conflict between whose authority or right that it's going to exercise, whether it is the local government or the national government, most of the time it is favored, okay, that it is within the right of the local government units rather than the national government units. Now, in the interpretation of the provisions of the code, the following shall apply. Any provision of the power of the local government units shall be liberally interpreted in the favor, okay, of the local government units. In case of doubt, questions therefore shall be resolved in favor of the devolution of powers. So, again, if there's a conflict and if it's clear, then we go by that principle that it is within the power of national government, then national governments will prevail. If it's within the power of the LGU, if it's very clear, then it's the LGU. Now, if in case of doubt, it will be resolved in favor of the local government unit. Again, the principle is the devolution of powers. So why is it so? It is because the national government unit diversified its task to the local government units, so so that it will not be a burden on the part of national government unit to do all the things which are very minimal, okay, so that it's now given to the local government units. And a fair and reasonable doubt as to the existence of the power shall be interpreted in favor of the local government units concerned. Now, we go into the powers of the local government units. There are sources of powers. One of that, of course, from the 1987, particularly in Article 10, which is the local government code or the local government in itself. The implementation of that, because it's not really clear, it's not comprehensive enough to address all possibilities that will arise later on. There is a code written by Pimentel, okay, one of the authors of that is a former I think Senator Pimentel, okay, the father, creating local government code of 1991. Okay, so the 1987, particular Article 10, and then we have the local government code and other special laws, okay, and the charter of the LGU. Those are the sources of the government powers and units. Now, as to the function of the chief executive and all the department heads or within the LGU, okay, it's basically found in their own charter, or if not if there's no charter, then by the local government code, which provides all the duties and functions of all officers. Okay, so these sources of powers here are arranged, okay, in a manner where the first one should prevail over the other, okay, the former prevails over the latter, which means that if there is a conflict between 1987 and the local government code, then there's the constitution, or 97 constitution, prevails over the local government code. And then if there's a conflict between local government code, okay, and the charter of the LGU, then the local government code prevails. Now, in the absence of that conflict, then the charter of the LGU prevails. So what is a charter of the LGU? The charter of the LGU is the law itself creating it. Okay, like in a highly urbanized city where their own laws are passed by Congress to become effective. So before it will become effective, or before it will be approved, it passed by the scrutiny of the local government, by scrutiny of the lawyers or prosecutors before it will be approved. And what are those reasons why it will not be approved? It may be contrary to the constitution or contrary to the principle of the local government code. Okay, so the charter itself is the law of the that creates it. Okay, so in case of conflict, then local government code prevails. If there's That's why a certain charter cannot be approved unless the provisions is contrary to the local government code. Now, there are 4 categories of powers exercised by the LGU. Powers expressly granted. Where can you find it? Basically, it's found in the local government code, where the certain LGU specifies its own powers. Okay, so you will know that later on, as soon as we discuss the powers of the chief executive, vice mayor, and all the officers. Okay, so there are enumerations of the powers. If it is not found within the enumeration, then they cannot function as it is. Otherwise, it will fall under a principle of ultra vires. Okay, meaning it's beyond its authority. It cannot go beyond their power enshrined in them by the local government code. So expressly granted. Another is powers necessarily implied thereon. Okay, expressly granted are very specific. It's found in the enumeration of the powers. How about those powers necessarily implied thereon? Okay, things that are in connection with or in pursuance to the purpose of which it was created, then that is called powers necessary implied thereon. Okay, so it is not limited only to the probably enumerations of the local government code. Okay, there are enumerations there, but it is not limited only to that, because even the powers of the president, okay, it goes beyond. Okay, like we mentioned in the discussion on the powers of president, like budgetary powers. There is what we call as the residual power. The residual power simply means that it is not in the enumeration of all the powers, but it is necessary by implication. Being a president has that power under the principle of parens patriae. Okay, parens patriae means the protector of the people. Okay, so it has a wide range of power that it is not even confined on the enumerations under the Constitution. Okay, so that is called the power necessarily implied thereon. Okay, so that could be a defense of a local chief executive if it acted even beyond its power. Okay, that it is necessarily implied thereon. But if it is contrary already, okay, like it was without authority from the Sangguniang concerned, then it may be considered as illegal. Okay, Now we go. Am I still clear? Can you Are you following? Okay. Now, um, the third is power necessary, appropriate, or incidental for efficient and effective governance. Okay, and the last is that the power essential for the promotion of the general welfare. So this may even be a source of a defense of the local chief executive. Okay, so on acting without the authority. Okay, it could be that it is a power necessarily implied therefrom, or it could be powers necessary, appropriate, incidental for efficient and effective governance, and the powers essential for the promotion of the general welfare. So that comprises the entire, as long as you do it in good faith. Okay. Anyway, or actually, if you only do things in good faith without malice or without a having in mind to corrupt, well, it's all safe. In fact, for a government officer, they are presumed to be acting in 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 performance of their duty. Okay, and there's a term for that. Even police officer acting within their scope, or which are questioned by the civilians on the arrest. Okay, what do you call that doctrine? What do you call that defense of government officials, okay, on matters which can be questioned, and like arrest, for example, of a civilian sometimes would question the arrest, and of course the arresting officer might be jeopardized and probably be dismissed or preventively suspended. But what could be the defense of these public officers? Okay, what do you call that doctrine? This is what we call as the presumption of regularity. So a presumption of regularity simply means that um, a government officials act, okay, in accordance with the law. Okay, that is presumed to be within the scope of their duties. So if you question its illegality, then the presumption that will protect the officer or even government employees that that act was in performance of their duty, and they are presumed those acts as um, regular. Okay, presumption of regularity. So there are that principle has been upheld by the court, and acquits government officers. So countless times I keep on mentioning that as long as you do it in good faith, nothing to worry about. Okay, because in the principle of criminal law, there are only two things which can convict a person. One of that is that the mind and the act must be incongruent to make a person liable. If the act is criminal, but the mind is not criminal, then you cannot convict a person. Okay, like, except of course if it is a special law. Okay, a special law, as long as the act is illegal, regardless of whether in good faith or not, still you will be convicted. Good faith is not a defense in a special law, but good faith is a defense in a penal law, in a criminal law or penal provisions. So there are two kinds of law, right? Basic, special, and special law and laws under revised penal code. Under the revised penal code, there are many laws, and a good faith is always a defense, meaning if your mind is not criminal, even if the act is criminal, you will not be imprisoned. But if it is a special law, like um, can you give me an example of a special law? Bausi, what else? Violation against women and children is special law. Good faith is not a defense. You cannot say, I have no intention of doing it. You cannot do that. It's not a defense. Um, corrupt and Anti-Graft and Corrupt Practices Act. Okay, you cannot say as a defense that I have no intention of getting the money. It's not a defense. Okay, as long as the act was committed, then it's all good. That will convict you. So so those are basic things that you should know. These are very important. Now we go into within their respective territorial jurisdiction. LGU shall ensure and support. Okay, one is the preservation, okay, and enrichment of culture. Okay, promotion of health and safety. These are basic to common to all LGU, whether it's province, city, municipality, or even barangay. Promote health and safety, enhancement of the right of the people to a balanced ecology, development of self-reliant scientific technological capabilities, improve public morals, enhancement of economic prosperity, of social justice, promotion of full employment among residents, maintenance of peace and order, preservation of the comfort and convenience of its inhabitants. So those are basic in all LGU. We go into the general welfare clause, its nature. So this is the basic allegation of the LGU's Act, that it is always in accordance with the general welfare clause. In fact, all of their actions supposedly must be for the general welfare. Okay, so this could be a ground for an LGU to exercise one of its inherent right, which is the police power of the municipal corporation, okay, which extends to all great public needs and includes all allegations, okay, and functions of the municipal government. So if you are a legislator, you have to make it sure that your legislation is all intended for the general welfare. Now, we go into the general legislative power. Authorizes the municipal council to enact ordinances and makes regulation not repugnant to law and may be necessary to carry out into effect, and discharge the powers and duties conferred upon it by law. So, the municipal council, barangay councils act must be in accordance with the general welfare. So their laws must always be for general welfare. But what is a general welfare? Anything that the public will generally benefit. And what do you mean by public? When can you say that it is indeed public? Okay, so I keep on, it was defined and argued by legislators what constitutes public. Okay, but there was a definition found in commercial law which actually specify a number when it can be considered as a public. Okay, and if according to them, if it is more than 20 people will benefit, then that's public already. Okay, if it's only less than that, then it is not for public. It can even be questioned. Okay, any project that will only benefit few is considered public, and it's private, it's not public. Okay, so if it is private, then government funds should not be intended for that. What happens if the project intended for a certain individual, for few individual, okay? Then those person who will be involved, okay, in the who benefits should pay, and not the government fund. Remember that the government fund actually was taken from the taxpayers, and the people who will be deprived are actually those who contributes more than those who benefits. Okay, look at those people who are benefiting. Normally, these are the people who are not paying taxes. Okay, and the reason why they do not have properties is because they are unemployed. Okay, and they do not contribute. This is the injustice here. While those who acquire property are those who are actually working, and out of their profit they buy properties, right? And later on, these properties will be taken for public use. Okay, and who benefits this public are those who are not paying taxes, and that is the inequality of government. Okay, so that's the thing that we have to look into. But sometimes in elections, the politicians like the people would be impressed, okay, by making a law, making a legislature that would benefit the the people. But out of this the benefit actually comes from the one that they deprived of their properties. Okay, so it is as if you transfer the properties paid by these people who are working to the non-taxpayers, who do not actually contribute for the national wealth. Okay, including those politicians who are unemployed, who cannot be employed in the place where they work, and perhaps the only way for them to earn money is running in politics. Okay, so, and remember, sometimes it's not always forever that they will be in that position. Who knows, in later on, those who are working might retire and then take that property, the property you have, in favor of other people, and what will be your reaction? Okay, so that could be the and the leveling factor, no, when time comes when those who are working, who are paying tax, and who were deprived by government of their taxes, of their benefit, will now retire and become politician, and then make a law similar to what they did, and now favoring taking their properties in favor of the low income taxpayers, or the people. Now, I hope you understand what I'm talking. I'm talking of a thing that are injustices done by politicians. Sometimes it would be unfair taking your property for their public use. Now we go into the police power. Police power proper authorizes the municipality to enact ordinances as may be proper and necessary for the health and safety, prosperity, morals, peace, good order, comfort, and convenience of the municipality and its inhabitants, for the protection of their property. Okay, that's the purpose of their police power. It can even destroy a building without payment of a just compensation, just to secure the public. So what are the limitations of that general welfare? The general welfare clause cannot be used to justify an act not authorized by law. Okay, not authorized by law. Now, sometimes what general welfare would mean is just a thing that the chief executive desire but not actually agreed upon by council. Okay, in many instances during meeting, it's the the presider normally speaks and no one will object. Okay? I experienced that when I was a board member of a certain subdivision. Okay, the president says and nobody objects, so that is carried out, and then it's not actually in general. If you only analyze, it's not for the for everybody. It's just that what the presiding officer desires or wants. That's why it's important that in a meeting there should be a discussion. Put the matters in the table or to be discussed, and let others people members speak pro or against it, and then decide by a vote. The majority decision prevails over the lesser majority, over the minority. Is it important to have it recorded? Yes, because that can be a reason later on to question an ordinance. Okay, whether it is indeed a public welfare by the majority of the votes of the council. If there's no majority, then it's not. Then it is not it's not for general welfare. It is not the voice of the people. It's just your own voice. Okay, and if it's your own voice, then you may be questioned. Okay, you may be held personally liable by doctrine of piercing of a corporate bill. Take note that a local government unit is a corporation. It's a corporation decided by the council. Okay, it cannot only be acted or cannot be decided only by one person. Because if only one person decides, and then later on the local government units as a corporation was deprived of the rights, then there may be a piercing of a corporate bill. Okay, piercing of a corporate bill means that there will be now a separation between the person and the corporation. The corporation itself doesn't bind the officers. So the officers without authority or acted illegally will be held personally liable, not the corporation. Remember, the money comes from the people. So the people's money must be authorized by the council. Okay, if you acted without authority, then it is not an act of a corporation, but your own act, and you will be held personally liable. You pay it by yourself, no, not from the fund of the government. Now we go into the two-pronged test of an ordinance to be considered valid police power. One is that formal, okay, and substantive, enacted within the corporate powers of the local government unit, and then passed according to the procedure prescribed. Okay, and what is that procedure prescribed? Well, following the parliamentary procedure. Okay, like notice to the notice to the persons involved, notice to the council prior to the passing of an ordinance. Okay, and notice now recently under the new corporation code can even now be in a form of the latest mode of communication, like text messaging or email. Okay, before the notice must be given, I think 2 weeks or even a week before the scheduled meeting. But right now they listen it because of technology. The presumption is that as soon as they send the message, you automatically receive it. Okay, and on that particular day. Okay, if it is emailed to you today, presumption is that you receive it. Okay, you cannot deny that you were not able to receive. Okay, before you can deny because it's difficult to find a person. Okay, especially if the person has several residences. But now they cannot escape. Okay, they cannot make a defense that they do not receive the notice as long as they give your cell phone number, email address, then that's good. It is presumed that you already received the message. Now we go into the substantive. It must not contravene the Constitution. It must be fair and not oppressive. Okay? So take note, before you pass a certain law, okay, a certain ordinance, it must be, it must not contravene the Constitution or any statute. So it is presumed that you know the statute and the Constitution. Unfortunately, those who are in the barangay are not educated. Some, of course, okay, some of them are just even an elementary, which do not have any subject in elementary Constitution. Unlike probably in high school, where there is indeed a subject in Constitution or certain laws. So of course, what can you expect from them if they do not have background in Constitution? So everything will be very chaotic. So you expect the worst if they are not educated. So it must be fair. What is fair? Okay, it must not be oppressive. Take note, when you pass that a certain ordinance, you are passing into a thin line. And what is that thin line? Or in a biblical sense words, it is called the what's that? It's a camel. There's a biblical word where I am a camel. Only a camel can pass. So, I'm not so religious, that's why I easily forget. But there is a portion there where it's difficult to pass, okay, because certain passage, a certain line, a certain passage, only a few person can pass. Similar also to making a law, okay, it must be fair and oppressive. It must not be fair, it must be fair and not oppressive, because if you go beyond it, there may be a possibility that a certain crime is committed. And what is that? Grave abuse of authority. Grave abuse of authority. Now, can a legislator be held liable if he pass a law which is oppressive on grave abuse of authority? Can he be liable? Okay. I think, in my opinion, he can, or they can be held liable for grave abuse of authority if it is oppressive. Okay, if it is very oppressive, where it's done with malicious intent just to deprive them of their properties, I think that can be a ground for grave abuse of authority, which is punishable under the criminal law, and which is a special law as well, where good faith is not a defense. Okay, in the Ombudsman Act, the person may be held liable for abuse of authority, abuse of right. Okay, so it's not as well a guarantee that when you work in government, everything will fall into your own side. Okay, and take note, once this case is filed, there is an automatic suspension. What are those cases where a person can be automatically suspended under the Ombudsman Act? What are those? Is it an automatic that if a case filed against a government official under the Ombudsman Act, a violation of Ombudsman or Graft and Corrupt Practices Act, the person will automatically be suspended? No, there are only 4 grounds where a persons can only be where a government of employee can be automatically suspended. One of that is that the person has the control of the documents, and the crime involved is morality. Okay, and that include grave abuse of authority. If you have the control of the documents, then you can be suspended right away upon filing of the case. There are two kinds of suspension, okay, and this will probably come out in your midterm final exam. Okay, preventive suspension, which is not a penalty, which is automatically given or imposed upon the filing of the case. Okay, for the preservation of the documents, and it is not always intended for all employees. There are only few employees who can be preventively suspended, and that person must be in control of the documents. Otherwise, as soon as the investigation starts, is going to destroy all the documents. And upon the findings later on that indeed the person is guilty, then there will be another suspension, which is now a penalty. Okay, a penalty, depending on the nature of the liability of the person. Suspension is just a minimal penalty. Higher penalty could be a dismissal from the public service without and with the attachment that a person cannot work anymore in government, or perpetual disqualification to work in government. That is the worst. That's the worst penalty. Okay. There are even some penalties where person is deprived of their benefits that will be received by government. One of that benefit is retirement benefit. Okay. Can you imagine of all the years that you work in government, it's just in a simple mistake, you are charged in in the ombudsman, and the penalty imposed is dismissal without qualification to work in government. Again, a perpetual disqualification to work in government. And disqualification to receive pension. Okay, so that is why while working in government, we have to do our best, live a simple life, do the 8 government employee standards. No, the last part there is simple living. Now, that's why I wonder why some of the politicians are so eager, and they do not fear that later on they may be disqualified. Okay, or they may be imprisoned. Okay, sometimes the cause of our misfortune is not because we are good. Sometimes it's caused by our ignorance. And as you know, in law, we have a saying that ignorance of the law excuses no one from compliance therewith. Even if you are ignorant, still you can be imprisoned. Okay? So, now I go into the... So, I don't know if you are still listening, but every now and then I'm going to check if you are there by posting a question, and then you're going to reply. Okay? So, I'm going to check if you are there by simply asking question later on. Now, I'll go into the next. It must not be partial and discriminatory. What do you mean by this? It does not only be, it must be for all. It should not only be against certain person. It must not prohibit but may regulate trade. Okay? So as much as possible, if there are there are income generating projects or income, could be a source of income, like a business permit passed by applied by a certain individual, as much as possible you have to regulate trade but not to prohibit. So for example, was the case in Manila, where it's the proliferation of the hotel on short time. Okay, so that's business. It's not all the time that people goes to hotel will do all illegal acts. There are people who goes to hotel for relaxation or for just to rest or sleep. So all you have to do is to regulate but not to prohibit business. It must be general and consistent with public policy. It must be, it must not be unreasonable. Okay, so these are defenses of a certain law that probably against the certain person, no? So you choose among all those instances where an ordinance may be invalidated. Okay, so it can be a ground for an ordinance can be invalidated by being unreasonable. It can be invalidated by being inconsistent with public policy. Okay, what do you mean by public policy? Things that are already agreed upon, or customs, okay, or a normal practices or norms of a certain society. That can be a ground for invalidating certain ordinances. It must not be partial or discriminatory. You can allege that it is partial or discriminatory. Okay, so this can be a ground. Um, it must not be unreasonable. So I think one basic ground for invalidating a certain ordinance is it must not be unreasonable. So example of this is the prescribing a zoning and classification of merchandise sold in public market. Okay, considered to be valid an ordinance. Condemning and demolition of buildings found to be in danger or ruinous condition. Regulation of operation of tricycles, still valid. Zoning regulation, valid. In the case of pataling, providing burial assistance to the poor, okay, valid ordinance. Enforcement of fishery laws, valid. Okay, prohibition of operation of nightclubs. Okay, it is lawful trade and pursuit of an occupation. So even then, if prostitution, I don't know, not prostitution, but similar to that, which is prohibition of operation of nightclubs. Of course, prostitution is illegal always. Rescinding of mayor's permits based on an arbitrary ground. Okay. Setting aside 6% of total area of illustration. Okay, example of illustration which is an invalid. These are now invalid. Okay. Nightclubs, prohibition of operation of nightclubs. Okay, similar to the example in my discussion on a hotel. It must only regulate business. Rescinding mayor's permit based on arbitrary ground. Okay, if it's arbitrary reason, then the mayor's permit may be illegal. It's invalid ordinance. Setting aside 6% of the total area of the private memorial type, it's illegal. Okay. We go now into another topic on eminent domain. Okay, this is another inherent right of the state, the to take private property for public use. It is a government right to appropriate. Okay, it is a compulsory sale, and then there will be payment What are the requisites of the valid? There must be an ordinance, not only a resolution, but an ordinance enacted by the local legislative council authorizing the local chief executive on behalf of the local government unit. So who has the power to exercise that eminent domain? Can the barangay exercise that local government power of eminent domain? The answer is yes. Okay, it can, because it does not qualify there whether the LGU refers only to municipal or provincial. The LGU includes a barangay, which also has that power to exercise eminent domain, to take private property for public use. Now, take note again of an ordinance, because if there is no ordinance that can that grants that power to expropriate private property, then that can be questioned. That can be questioned, okay, as there's no authority granted by the chief executive. Okay, and as I said, they are not, the local government units sometimes are not well versed in this procedure of taking private property for public use. So they can be attacked technically on that. Okay, one of which is the quorum. Okay, who were there? Where are these officials voted for or against? Was it set in a table to discuss it properly, and who voted for it? Okay, that can be questioned. Or was there a proper summon or notice for a meeting, okay, for this particular purpose? Was those person involved invited? Okay, those are things that can invalidate a certain ordinance on the exercise of eminent domain. And so this expropriation proceeding is a court action which is beyond pecuniary estimation. If it is beyond pecuniary estimation, meaning it cannot be ascertained of how much, so in the jurisdiction of the court, if it is uncertain, then it is the regional trial court. There is a jurisdictional amount for a certain case to be filed right now, and under the modern or under the latest jurisdictional amount of the MTC, it's I think 400,000. Higher than 400,000, it's the RTC. Okay, on the amount of properties. If you pass or if you file a case without minding that a jurisdictional amount, it can be dismissed. So lawyers should be well versed on the jurisdictional amount, because if you file it in the wrong court, it will be dismissed automatically. Expropriation proceeding is it's beyond pecuniary estimation, therefore it is the regional trial court which has jurisdiction over the case. Are you still there? Okay, I only hear one. Probably I only have one student. Anyway, let's continue. Test will be given later on. You listen. Now, the eminent domain pursuit of expropriation proceeding over a particular private property, the power is exercised for public use. So again, you have to distinguish which is public and which is private. Okay, it must be for the benefit of the welfare, benefit with the poor and the landless. The payment of the there must be payment of the just compensation. It is the actual value. Okay. The expropriation, if the property owner agrees that it will be taken, then still there will be expropriation. Okay. The purpose now is for the determination of the fair market value or the just compensation. Because if it is offered and then the owner agrees, then there's no need of expropriation. Okay, but if the owner was not notified, then there could be expropriation, but still it is not automatic that the court will that the government will take the private property. Otherwise, it would be you may deprive the owner of their right to property. So still there will be court proceedings. Okay, they will determine whether it's reasonable or not. Okay, or whether they follow the certain procedure. If they do not follow a certain procedure, it will be dismissed. Okay. Now, a valid and definite offer was previously made to the owner of the property, but the offer was not accepted. Okay. So, it cannot proceed immediately to expropriation if there was no offer. The offer 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 above amount. Okay. So, if expropriation proceeding was initiated but there was no offer yet, that expropriation proceeding can be invalidated. Okay, the lawyer might question its uh, the that they do not follow the procedure. The procedure was that before you expropriation, there must be a valid offer to the owner. Jurisdiction, RTC, subject to the expropriation suit, is the government exercise of eminent domain, a matter that is incapable of pecuniary estimation. I explained that already. So it must be for public purpose. Okay, a very foundation of the right to exercise of eminent domain is genuine necessity. Okay, and necessity must be for public. It must be of a public character. Okay, if it is not a public character, again, it's a long discussion, no, to determine whether it is public or not. Okay, there are certain things to consider before it can be considered as public. Okay, so moreover, the ascertainment of the necessary must proceed with the company or a company and not follow the taking of the land. Necessity does not mean an absolute but a reasonable and practical necessity. Okay, it must be practical. If it is not, then if you have other projects still and you did not focus on it, okay, or you prioritize other not important, then it may be considered as not necessary. So again, there must be a valid definite offer. A valid definite offer means must be complete, including with a sufficient clearness of kind of contract. So you can even question the expropriation if there was no offer and there's no contract yet. They just simply take your property. No, they cannot do that. Okay, they have to clarify, explain first what will happen. Otherwise, you will be deprived of your property. Okay, the amount as well. It cannot only be for fair market value. It could be that the loss to the property because of a project. You might be deprived of your property because of the project. So that can be counted in determining the value of the property. It's not at all times a fair market value. It could be the damage that it costs, which is determined in court, a reasonable amount. Now, what happens if there's no expropriation, but the government takes your property without payment or resolution by the council? You have the right to be paid at the time when the government benefits and at the time that you were deprived to use the benefit of the property. That is called inverse expropriation. Inverse expropriation. I think that's the correct term, no? Okay. You check me if that is the correct word, no? Inverse. It's a court proceeding where the owner of the property will be paid on the amount of the loss when the government um, take take the property without payment or without expropriation. Okay, that is called inverse condemnation. That's the exact term. Inverse condemnation. Can you read the meaning of inverse condemnation? As explained in a certain case. Do you have it there? Read it for me. Can you search? Oh, anybody?
Inverse condemnation law
Mm.
is a legal concept and cause of action used by property owners when a governmental entity takes an action which damages or decreases the value of private property without obtaining ownership of the property through the use of eminent domain.
Ah, okay. So, yeah, that's it. It may not be the legal definition, but there's actually exact case of that um, specific case that explains well the meaning of inverse condemnation. So, um, you can actually ask government for its payment, okay, and the action is called inverse condemnation. So, it's not all free after all. You have to be very careful if you work in government. It's not all free that you can simply take private property for public use without following that procedure. Otherwise, again, you will be held liable for the payment. Okay, so the action to get back the the damages, or to take that amount of the just compensation that you were deprived and you were not paid, is called inverse condemnation. Now, so there are requisites for the entry of the LG: filing of a complaint for expropriation, sufficient in form, substance, deposit an amount equivalent to 15%, okay, of the fair market value of the property, and then the tax declaration of the tax declaration. So we proceed to taxing power. And I think I already discussed this one. Um, yeah. We go to the closure and opening of roads. Okay. Who owns the road? Okay. Generally, it is state owned. It's beyond commerce. It cannot be closed for a certain private purpose of or economic purpose. Okay. So example that can be questioned, no, by the taxpayer is the the use of public road for for economic purposes, like making it as a market. Okay, that's not allowed supposedly. Okay, why? Because it's all intended for public use and it's not intended for private or economic purposes. So it's beyond commerce. Um, so closure must be temporary only. Okay, or the kind of closure. So what are the requisites of a closure? Valid ordinance may be done due to actual emergency, fiesta celebration, public rallies, okay, agricultural and industrial fairs, okay, undertaking of public works and highways, telecommunications and waterworks projects. Duration of the closure must be for a specified local chief executive, okay, in a written order, and If it's for the purpose of athletic, cultural, and civil activities, this must be officially sponsored, recognized, and sponsored and approved by the local government units. So, can there be a closure of roads permanently? Must be via ordinance, approved by two-thirds of all the members of the Sangguniang concerned. Okay, take note of the number. It's not just an ordinary majority. Okay, two-thirds is required. When necessary, an adequate substitute for the public facility that is subject to closure should be provided. Now we go into the powers of the legislature. So the one that I discussed normally are the executive branch, no, exercising its power. Now we go into the power of the legislative branch, which generally to make laws, okay, or ordinance. There are two-pronged tests for an ordinance to be considered valid. Okay, a valid police power measure under the Police Power General Welfare Clause. One is that the local legislative power shall be exercised by the sangguniang panlalawigan of the province. Okay, sangguniang panglungsod if it's for the city, sangguniang bayan for the municipality, ang sangguniang barangay for the barangay. Okay, so here the first one presided by the vice governor. Second, the sangguniang panglungsod is presided by the vice mayor. The sangguniang bayan presided by the vice mayor, while the sangguniang barangay is presided by the punong barangay. So that is the unique setup among the LGU. Of all the upper part up to the municipality, it is presided by the vice. Okay, but in the punong barangay, there's no vice, so it is the punong barangay presides the meeting. That is why you cannot find veto power in the barangay. Okay, the veto power is the power not to approve passed by an ordinance passed by council. Unlike in province, city, municipality, where the chief executive, the governor, the mayor, or the city mayor in the case of the city, can actually veto. Okay, a veto means a power not to approve a certain legislation. But that can be overridden by two-thirds votes. So even if he does not sign it, it can be overridden, meaning it can still be approved if two-thirds of the council approves. Okay, so that is overriding a veto. In sangguniang barangay, there is no veto. Why? Because the punong barangay sits and even presides the meeting, and he cannot question the law he passed. And after all, he was there during the meeting or during the deliberation of a certain ordinance. He could have hashed it during the meeting, not to veto it after signed by everyone. Now we go into the distinction of the ordinance and resolution. So I discussed this one. Ordinance has a permanency, while resolution is not permanent, temporary in nature. It's passed by a lawmaking. It is a power of a law, while a resolution is just a mere expression of the ideas or the opinion of the majority. So I discussed the presiding officer already. No, we'll not discuss this one. Now there are also rules that they are going to follow aside from the rules provided by the local government code. They can actually make their own procedures, and normally these are conducts during the meeting. Even in Congress, they have their own conduct, not generally the parliamentary procedure. In fact, they can even cite a person in contempt or can arrest somebody. That's found in their procedure. If you do not misbehave, there may be a certain policy that they agreed upon. Okay, so that's called the internal rules of procedure. Okay, in the regular session following the election, its members within 90 days thereafter, the Sanggunian shall adopt an update of the existing procedure. So they can make their own procedure as to how they're going to conduct a meeting. Normally, it's all lifted from the parliamentary procedure of the Robert Rules of Order. A Robert Rules of Order is a rules of conduct, okay, adopted by Robert when he was still working in the parliament in United Kingdom. Okay, he observed that people are not observing well, and there are people who are chosen by the people but cannot speak because other representative dominates or in fact consume the time without giving time for others to speak. Okay, so right now, because of parliamentary procedure that everybody adopts, everybody has given opportunity such that no one can speak even beyond 3 minutes or even 3 times. So much as possible, you can only deliver a speech once to give an opportunity for others to speak and share their opinion. Am I clear?
Yes, no.
Okay, so good that you are still there. So let's proceed. Rules of procedures that provide for the organization, no? These are they can also create a committee aside from that. Now, there are actually committees provided for under the local government codes, but sometimes if the need arise, like there is a need that should be addressed immediately and there's no standing committee at the time, the council can make their own committee. Okay, it depends on the need. Really depends also on the in organizations. It all depends, no, if there are like cooperative, for example, like credit committee, education committee for the training of the new members. Okay, it's all embedded in their guideline, in their rules. But if there are other needs that they're going to arise, that will arise later on, they can actually create another committee. Same also with the rules that they follow. There are already committees, there are committees or offices provided under the local government code for municipality, city, and even barangay. But then it still has the power to create a committee based on the need. Okay, and they are not precluded from doing that, okay, as long as their budget provides. The rules and procedures that provide for organization of the Sanggunian and the election of its officers. Creation of a standing committee, and then the order and calendar of business. What do you mean order of business? Refers to the agenda. Okay, the agenda as I discussed in the parliamentary procedure. The agenda starts with the call to or determination of the quorum, then followed by the roll call or reading of the minutes, call to order. Call to order meaning the presiding officer gets the gavel to start the meeting and ends with adjournment. Okay, and prior to that, there are things that they're going to discuss, and also including new business or um, unfinished business if there are business that wasn't discussed or finished during the previous meeting. Okay, so this is the process, parliamentary procedure as I discussed. Disciplinary rules of the members, like the conduct of unbecoming, like disrespectful. You are not allowed to even mention unpolite or things that are negative. Some presider would not accept or even put a person out of order if they are misbehaving or using a word that is not acceptable, like saying a negative words against a person. So you have to be very cautious and courteous on what you say. As much as possible, you have to respect every member of the council. Address him with proper distinction. Okay, like honorable member of this council, or if you don't say a name, just a representing a certain district. If it's congressman representing district of Cebu City, without mentioning the name, that could be a best uh, polite way of addressing a person. And of course, you've heard of many instances, no? um, Meetings conducted by a certain committee in in Senate, that's they address themselves politely and they're very courteous. Unlike in our meetings, sometimes we behave like animals, as if own we own the hall, the house. It's our house, that we are the kings. No, inside that hall, we are all equal. You are all equal. So you have to address them um, with politeness and courtesy. Quorum. You know what quorum? It's a number that is required for it to start a business. Of course, you know it already. Um, you know what's a quorum already. I will not discuss it anymore. Sangguniang session, regular and special. Regular, it is found in the Constitution. Okay? Regular session, first session during the election. The Sangguniang shall, by resolution, fix the day, time, and place for the regular session. They have to agree on their availability when they should meet. And there's also a special and then minimum number of regular sessions. So they have to determine based also on the as provided for under the Department of Interior and Local Government. Take note, this agent, the governor, city mayor, province, aside province, city, municipality is under the Department of Interior and Local Government. So their head is the secretary of the DILG. So if there are administrative cases filed against the mayor, it will be filed in the secretary of DILG. Only administrative. In criminal, you can go directly to ombudsman. Okay, what are those administrative? Like absent or miss. Anything in relation to their job as a governor, city mayor, or municipality. So they will be they will be dismissed if the secretary of the DILG finds them guilty. Okay? So you cannot go directly to court unless you exhaust again the administrative remedies under the principle of exhaustion of all administrative remedies. The court will not entertain unless you exhaust all the administrative agencies on administrative cases. What is administrative exhaustion of administrative remedies? You have to exhaust all possible administrative agencies that is under whose power or who has jurisdiction over a certain government employee. Can they also be held liable under the civil service? The civil service will always remand it to the DILG because it's under the DILG. Okay. Special session may be called by the local chief executive or by majority of the Sangguniang. Okay. So, what is special session other than regular? And what's the content of the special session? Only specific matter. You cannot just have a special session discussing all matters. No. When it's a special session, it's special because it will only tackle one item. You cannot have two or more session or two agenda in this special session. Okay. Otherwise, if there are other items that you have to discuss, then reserve it for the regular session. So may be called by the local chief executive or by majority of the Sanggunian. So there are two who can call for a special session. Meaning it is not in the regular session. It's not on the particular day. So it can be called, especially if it's important, by the local chief executive or the majority, meaning half or 5 members if there are 4. If there are 8. So I already discussed what is a veto and, and item veto. So it can override by 2/3 votes. Now we go to an important part of an ordinance. Okay, there are ordinances that requires publication, and there are also ordinances that does not require publication. Generally, an ordinance that has penalty requires publication. What's the purpose? The purpose of that is for the due process. Okay, so publication of a penal provision is in conformity with the due process clause of the Constitution, that no one will be deprived of life, liberty, or property without due process of law. Now, we go into that applies to ordinance and resolution approving local government plan and public investment program. Okay? So, generally, ordinances, okay, and resolution approving local government plan and public investment program. Now, publication effectivity in a bulletin board, okay, at the entrance of the provincial capital, okay, meaning it's it must be published by the people by posting it in a bulletin board. What's the purpose of publishing it? For notice to the public, so that everybody will know. Okay. So in highly urbanized component city, highly urbanized or independent city like Cebu City, in addition to posting of the main features of the ordinance published, it must also be published in the newspaper of general circulation. And general circulation means that the newspaper that is circulating within the locality, within the area. So it must be 10 days after the posting unless otherwise stated in the ordinance. What do you mean by stated otherwise in the ordinance? If the ordinance states that it is effective on this particular days, then that will be followed rather than the 10 days. Okay? So otherwise, that's the meaning of otherwise stated in the ordinance. If the ordinance states it, just like the family code which took effect, that it will become effective after I think 1 year. So that's the effectivity. It's not effective right after the publication. Okay, generally after 10 days or after 15 days. Okay, but if the law specifically states a certain date for its effectivity, then that specific date prevails over 15 days or 10 days publication. Okay, posted in a permanent. Okay. So others are just a matter of reading. This can be understandable.